You want to be an Indian today? Good. The next speaker I want to introduce is probably for us, along with Professor Miller, is one of the foremost leading experts on the doctrine of discovery and its impact on indigenous peoples, not only in this hemisphere, but throughout the world. Steve Newcomb is one of the persons we call when we have issues. In fact, some years back, we sat down at the United Nations on, I believe it was the 3rd or 4th level of the building. Normally we don't get to go up there, but I think because we had Chief Oren and Lyons and a couple of heavy hitters, we were allowed to sit and speak with the papal nuncio, who is directly a representative, obviously, of the Vatican. And during that time, the papal nuncio had flanking his right and left two extremely intelligent young lawyers from Yale and I believe Harvard. And we brought up the topic or the doctrine of discovery. And Steve continued to berate the lawyers about the history of doctrines of discovery, and they took notes because they themselves did not know much about it. But at that time, the papal nuncio said that they were void and that they were not in existence anymore. Again, Steve Newcomb argued about Johnson v. McIntosh and about other cases that have taken place, and still to this day, cases that impact indigenous peoples here in the United States and throughout the world. So I want to bring up Mr. Steve Newcomb, one of the most renowned researchers on the doctrines of discovery. Steve? Cool.
Good morning. I want to pay my respects to the ancestors of this land, the O'odham people, and to acknowledge their traditional territory, and also to acknowledge the representatives of the state of Arizona, Representative Hale and Senator Jackson, and say I'm very happy to be here. Some of these subjects that I'll be talking about are a little bit challenging because they do go into the organic concepts, the originating concepts that had resulted in so much devastation for our nations and peoples. I'm actually Shawnee and Lenape. Our people, our nations are from back in the eastern seaboard area. And so it's interesting to look at how all these things have affected, these doctrines as they're called, these concepts, ideas have affected so many nations and peoples throughout the world. I want to mention that I think it's key and critical in terms of looking for solutions to honor and respect each and every one of the indigenous nations throughout this land, this continent, this hemisphere, and to speak in terms of the present day territories of our nations and peoples. For example, I work with the Sycuan Band of the Kumeyaay Nation, the Kumeyaay people in the Kumeyaay territory, which is today commonly known as San Diego. But when I travel, people say, "Where do you live?" And I say, "I live in the Kumeyaay territory," now today commonly called San Diego. I make sure that I acknowledge that that is still existing, because thousands of years of relationship culturally and spiritually of a particular nation or people with their land and with all the elements of life within those ecosystems, with the waters and everything, that cannot be just negated or canceled out because some other people show up to a shoreline and plant their flag and their cross in the sand or in the land. and then make some proclamation in front of a notary and make it an official document to say that they have created rights of sovereignty in that place when they're from somewhere else. And so I want to make sure that I start out by acknowledging that. The other thing I want to mention is that what are these documents we're talking about in terms of the documents issued by the Holy See, what is now commonly understood as the Vatican? And why are those documents so important? When you look at the language of those documents, which I'll quote in a moment, you'll understand some of the reasons why they result in behavior that has been so destructive all throughout the world for indigenous nations and peoples. For example, a papal document issued by Pope Nicholas V to King Alfonso of Portugal in 1452, the Pope instructed or authorized the king to go to the western coast of Africa, and this is the direct quoted language, to invade, capture, vanquish, and subdue all Saracens, pagans, and other enemies of Christ, to reduce their persons to perpetual slavery, and to take away all their possessions and property. And the instruction in the document is that they are to convert the land. Of course, they're to engage in religious conversion, but this is specifically to convert the land of the African peoples. And in that context, the word convert means to unlawfully or wrongfully appropriate that which belongs to another. And because that's the understanding of the word convert, in the very next sentence or the very next section of the document, the Pope declares the actions to be just and lawful. Those kinds of doctrines, that was in 1452, but in 1455, 56, 1481, 1514, other Portuguese-oriented papal documents were issued. But then in 1493, you also had the documents issued by Pope Alexander VI regarding the voyage of Cristobal Colon, otherwise known as Columbus. And in that document, you find some key phrases. And by the way, these documents are found in a book called European Treaties, bearing on the history of the United States and its dependencies to 1648, published by the Carnegie Institution in 1917. And you can find them in both Latin and English. And any of you very diligent students, I highly recommend that you look at the Latin, go deep into that Latin language, because that's the language of the Roman Empire. And it's a language system that explains so much of what's going wrong in the world today. But those papal documents from 1493, there are several of them. And there's one sentence in particular in Latin, and it states, sub dominio actuali temporali aliquorum dominorum Christianorum constitute non sint. And what that means in English is not under the domination of any Christian dominator. And so that dominorum Christianorum is a critically important concept because it's the idea of Christian domination, Christian dominator. There's another sentence in that document that says, we trust in him, with a capital H on him, from whom empires and dominations and all good things proceed. And the word for dominations is translated into governments in English. So the singular word for government in that context is dominacion in Latin. So these are very critical, important points and important concepts because they do explain why there are supposed to be checks and balances on government. In other words, the law, the rule of law, is not simply to be there for the people, quote unquote, but it's actually to hold checks on governmental officials and to hold them in check to curb their activities and their actions so that the deadly kind of lethal power that they have at their disposals is held in check by certain things such as a Bill of Rights and so forth. Now, when you trace these documents back, or all forward rather, in history, what you'll find is that the papal documents, along with royal charters of England and many other kinds of charters, which were grants of rights to land and grants of presumed rights of dominion and so forth, you find the organic laws, the source of the organic laws of the United States. And so, for example, before I came here, I thought I should look into how these doctrines of discovery and domination relate to the history of Arizona. So I looked in a book called Federal and State Constitutions, Colonial Charters, and Other Organic Laws of the United States, published in 1877 by the United States Senate and the U.S. Government Printing Office. And what I found is that what gave birth to the territory of New Mexico was an agreement between the Republic of Texas and the United States. And then that Organic Act of New Mexico, the Territorial Act of New Mexico, gave birth to the Organic Act of Arizona. And that resulted in the territory of Arizona. But I still wasn't finding in those two documents anything that seemed particularly relevant. And so what I did was I looked more closely at the language on Texas. But in order to do that, I'm using Google Books. So I go back to the table of contents under Texas, and what I look at there is it says, right under Texas, it says Spanish claims of dominion in the Americas. And then I go back to the book and look under Texas. I'm not finding it. So I have to look more carefully at the table of contents. And then I see it refers me actually to a much earlier part of the book, pages 304 and 305. So I go back to those pages, and that refers me to Florida. And interestingly enough, the organic documents, the originating documents for Florida, given in this book published by the United States Senate, pardon me, are two different documents. One, the royal prerogatives granted to Columbus in 1492, and the second document is the papal bull of 1493 issued by Pope Alexander VI to the monarchs of Spain. And that's the very document in which we find the very troubling concepts about domination and so forth. So that means that there's a direct linkage to the organic documents of Arizona, New Mexico, Texas, and as a matter of fact, also to California and Utah and Idaho and Colorado, and they all trace back to the Spanish Crown Law and to these other documents. Interestingly enough, in the Constitution of the Republic of Mexico in 1824, there's actually a section under the Supreme Court of Justice, as it's called, to make sure that the court is cognizant of the pontifical bulls, briefs, and rescripts in all matters litigant. So in other words, they're to actually reference the papal bulls as part of their judicial oversight in looking at that's within the scope of their work, in other words. So these are fascinating ways in which all of these ideas give rise to patterns of behavior and claims of territory and dominion on the part of the United States government and various state governments, to the detriment of indigenous nations and peoples. In Johnson versus McIntosh, there's a key line that tells you how this all works to carry it through. And this is from Chief Justice John Marshall in Johnson v. McIntosh. While the different nations of Europe respected the right of the natives as occupants, they asserted the ultimate dominion to be in themselves, and claimed and exercised as a consequence of this ultimate dominion a power to convey the soil while yet in the possession of the natives. So if you parse that, you pull it apart and you delve deeply into it, it's the idea that they have, just by showing up, They have somehow inherent within themselves this right of Christian domination or Christian dominion, as it's euphemistically called, and that the Indians, the heathen original nations and peoples, actually have merely a right of heathen occupancy. And so that terminology is used throughout. Now, in 1954, there was a case that went before the U.S. Supreme Court called Tehitan Indians versus United States. And the United States government created a legal brief for that case, and I'm going to quote a couple of lines from that because I think it's critical and it links to what Julie Fischel and Professor Miller have presented on the doctrine of discovery. And under the category, under the heading of argument, the United States government wrote this, quote, "Prior to the great era of discovery, beginning in the latter part of the 15th century, the Christian nations of Europe acquired jurisdiction over newly discovered lands by virtue of grants from the popes, who claimed the power to grant to Christian monarchs the right to acquire territory in the possession of heathens and infidels." Now that's direct language from the United States government to the U.S. Supreme Court in 1954. And it continues. For example, in 1344, Clement VI had granted the Canary Islands to Louis of Spain. And following the discovery of the New World by Columbus, Alexander VI in 1493 issued bulls granting to Spain all lands under Christian rule. It was necessary for the civilized Christian nations of Europe to develop a new principle which all could acknowledge as the law by which they should regulate, as between themselves, the right of acquisition of territory in the New World, which they had found to be inhabited by Indians, who were heathens and uncivilized according to European standards, unquote. So they're using the exact framework that we're talking about here today in their method of argumentation, and the Supreme Court actually ruled in favor of the United States position in that case. And when you look at the Tehitan decision, you will not find language specific to Christians in their ruling. They do talk about the idea of the idea of Indian title being by permission of the whites to occupy the land. But what the Supreme Court did do in its ruling is cite to Henry Wheaton's Elements of International Law, published in 1836. And I'll just read you a very brief section of that. It says, according to the European ideas of that age, the heathen nations of the other quarters of the globe were the lawful spoil and prey of their civilized conquerors. And as between the European powers themselves, the sovereign pontiff was the supreme arbiter of conflicting claims. Thus the bull of Pope Alexander VI reserved from the grant to Spain all lands which had been previously occupied by any other Christian nation, and the patent granted to Henry VII of England to John Cabot and his sons authorized them to, quote, "seek out, discover, and find all isles and regions and provinces whatsoever that may belong to heathens and infidels, and to subdue, occupy, and possess these territories as his vassals and lieutenants." It thus became a maxim of policy and of law that the right of the native Indians was subordinate to that of the first Christian discoverer. And so that is actually what the Supreme Court cited to in its decision Tehitan. When you start to look these concepts up, so for example, conquest, conqueror, and so forth, conquer, and subordinate, all these types of terms, there's actually a structure that's been identified by an amazing international law professor named Anthony Angie, and he has published a book called Imperialism, Sovereignty, and the Making of International Law. And in the foreword to that book, written by James Crawford, a very eminent international law professor, he mentions that there is a structure of domination and subordination that Professor Angie has identified in international law. And what I've begun to understand is that there's a specific vocabulary of dominance or a vocabulary of domination that has been used repeatedly throughout all these various cases and continue to be used today. And that once we identify that vocabulary, we're then able to decode and understand exactly how that system is operating today. So I think this is critically important because the UN Permanent Forum on Indigenous Issues is going to take up the theme for this year's upcoming Permanent Forum from May 7th to May 18th is the continuing impacts of the Doctrine of Discovery on Indigenous peoples, but also redress for past conquests, which when the Tanya Ganella Frischner submitted a paper called the Preliminary Study on the Doctrine of Discovery to the Permanent Forum in 2010, that was not stated in there, nothing about conquest, only about dominance and so forth, the framework of dominance that was clearly identified in that paper. So what I see is that there's this effort to try to reframe what we're calling attention to in terms of conquest, because conquest has a legitimacy under international law. And you could say that's over and done with, you're conquered, that's the way it goes. But domination does not have legitimacy under international law. And at least there's no doctrine whereby you could point to and say, yeah, that's considered acceptable. And so what we're pointing out is that domination results in massive destruction. It results in the suicides in our various communities and among our nations. It results in the destruction of waters. And it results in so much that's very problematic that needs to be dealt with and addressed. So what I see is that the non-Indian society has actually deprived itself tremendously by dehumanizing and subhumanizing indigenous peoples. They have deprived themselves of being able to learn from the vast amount of knowledge and wisdom that indigenous nations and peoples have been able to accumulate over thousands and thousands of years, going back to the beginning of time as expressed in our oral histories. And so that's what needs to occur. Once this understanding of respect for the original laws of the land, for the original nations and peoples of the land, once that begins to occur, then there's going to be more of a flow of communication, and that knowledge that's been buried and suppressed is going to rise up. And if you want a clear understanding of what that knowledge and wisdom entails, look at the book called 1491 by Charles C. Mann. It's an amazing exploration, or so to speak, or an amazing understanding of just how incredibly wonderful and rich and vibrant and intelligent indigenous nations and peoples and their cultures and spiritual traditions have been and continue to be at this time. So the reason why there is language such as Shannon talked about, the autumn uprising, is because there's a word, that term uprising, you're down and you're rising up. The reason for that is because of a Latin term called deprimantur. Deprimantur means to push down, press down, weigh down, oppress, like to hold down. And so when the people are trying to reverse that, they're trying to come up. And that pushing down is the dehumanization, subhumanization process. So I won't go much longer. There may have been some other things I was thinking of talking about, but basically that covers the main gist of what I want to say today. And I really appreciate your time and attention. I will mention one other thing, and I'm glad I remembered it, because there's a term in English. You know, the dictionary is a wonderful tool for all of you students in the room, and anyone else for that matter. I've used dictionaries, and very old dictionaries, in my work for many decades now. And I'm always finding new things that I never understood before that should be very obvious, but they're not. For example, the word civilization. I recently was looking up that word, and it just jumped out at me. Maybe because I'm looking at it now with so much kind of a different perspective from so many years of research, but it hit me because it said the act of civilizing, especially the forcing of a particular cultural pattern on a population to whom it is foreign. The forcing of a particular cultural pattern on a population to whom it is foreign. When you impose or force another cultural pattern on a people, and especially if that cultural pattern happens to be one of domination, well, the forcing itself is also part of that domination. So when they say uncivilized, they're really talking about undominated, those who have not yet been subjected to that process of domination and assimilation. So the healing that is critically important, the revitalization that's critically important, involves coming to a deeper level of understanding for ourselves that we're not conquered. It's not a conquest that they've accomplished and achieved, and that's just the state of things. It's very important to understand that word is. Four very key words in English are supposedly, purportedly, so-called, and allegedly. Because when we're looking at Supreme Court rulings, there's the tendency to say, well, it is this way because Supreme Court such and such says this, that, and the other. And I don't do that. I say they allege that it's that case, or they're purporting or deeming something. It's these concepts. The greatest way to think outside of the box is to realize it's not even a box. It's an idea about a box. And these are concepts and ideas that we have a perfect right as the original free and independent nations and peoples of this land to fully expose, to shed the light of understanding upon them so that we can come to a better understanding and appreciation of each other as human beings who have a sacred role to live in right relationship with the original laws of the land, air, water, sun. Thank you very much.